thank you everyone for coming. Just a bit of background in terms of these webinars. This is the second in the series. Hopefully there will be some more, but it's sort of come about as a result of actually me being introduced to the work of the British Institute of Human Rights and their webinars and the excellent campaigning that they're doing to protect the Human Rights Act and our human rights generally in the UK. Most of my career has been spent working with marginalised communities and campaigning for disability equality in particular. I was part of the UK delegation to Geneva in 2017, where we submitted evidence to the UN Committee on the Rights of Disabled People about the human rights violations of the UK government against disabled people in the UK. The Human Rights Act was just such a crucial tool for us, and the UK government was consequently condemned by the committee for violating people's rights in a way that amounted to a human catastrophe. And the UN Rapporteur on Poverty was similarly scathing about the impact of austerity on widening inequalities and damaging people's human rights in the UK. So, I'm really pleased that we've been able to partner with the British Institute of Human Rights to organise this webinar. And we're delighted that we will also be joined by Charlie Welton today from Liberty. So we'll be focusing on understanding the Human Rights Act and other threats to our human rights, journalists' rights, and also freedom of expression, and take a look at what we might be able to do about that. So I will hand over to Carlin Miller, who is the Head of Policy and Programmes at the British Institute of Human Rights. So thank you very much.
Thanks a lot, Natasha, and thank you again for having us here. So I'm Carlin Miller. I'm the Head of Policy and Programmes at the British Institute of Human Rights. And what I'm going to try and cover today, let me just check my time to make sure, last time we covered an introduction to the Human Rights Act, and we covered kind of how the Human Rights Act works and what it means for journalists, and we looked at a couple of the rights within the Human Rights Act. So today I'm not going to spend much time at all talking about how the Act works, and I'm just going to focus on Human Rights Act reform, sort of how we got here, why we're concerned, and what that means for journalists. And I'll end on some top tips for journalists as well. So this is my only slide on the Human Rights Act and what it does, but essentially human rights law sets minimum legal standards for how the state treats people. So it's a bit of legislation which sets out how the state should treat people when people are interacting with the state. The Human Rights Act in the UK, passed in 1998, it brings the rights within the European Convention on Human Rights into domestic law here in the UK. So it brings down the same rights within the ECHR into domestic law, meaning that we can take a case to court here in the UK. Still have access to the European Court of Human Rights in Strasbourg in France, because it's a Council of Europe document rather than a European Union document. And the definition of the state under the Human Rights Act is really broad. So it's falls on anyone delivering a function of public nature, rather than just maybe what we would consider traditional state bodies like the police or the NHS, for example. Section 6 of the Human Rights Act puts the legal duty on any body, certain of whose function are functions of a public nature. So basically that means that if a body's delivering a public function, like health or like care or like education, they have a legal duty to respect and protect human rights. And that's really good because it means that the safety net for people is broader. So let's say you have a family member in a local authority care home and another family member in a private care home, which is funded by the state. They both have the same protections under the Human Rights Act. Human Rights Act says that our rights should be protected at all times, especially during times of emergency, and we all have the same rights. Some of our rights can be limited or restricted in certain circumstances, and that's what we covered on the first workshop round about which rights are absolute and which rights are non-absolute or qualified. So some of our rights can be limited or restricted by the state in certain specific circumstances, where there is a law that allows the state to do that, where it's necessary to protect us or others from harm, and where it's the least restrictive option available to the state. So there's a sort of legal framework for how that works and which rights can be restricted and which rights can't be restricted. So I'll not say any more on that, and I'll just move straight on to what's happening. So in December 2019, the Conservative Party manifesto promised to update the Human Rights Act. And then in December 2020, the UK government announced that they had put together an independent panel that was going to review the Human Rights Act. That was called the Independent Human Rights Act Review, and it ran from January to March 2021. And lots of people submitted evidence to that review about the Human Rights Act and how it was working. That closed in March 2021, and we then didn't see the report of the panel until October 2021. Well, actually, that's not true. The government saw it in October. We didn't see it until the 14th of December. And on the same day that the report was published, the government published a consultation on replacing the Human Rights Act with a modern Bill of Rights. So that wasn't what had been consulted on. What had been consulted on was the Human Rights Act and whether it needed reform. But then we saw the report from that and a consultation paper which proposed something completely different, which is a new Bill of Rights. That consultation is open now, and it's open until the 8th of March. So if after what you hear today, you feel like it's something that you want to respond to, you've got a bit of time still to do that. And we've got lots of resources to help you do that as well. So this time last year, we responded to the Independent Human Rights Act Review, just some stuff from our own response. Unnecessary was the most common word used in survey responses. When we asked people what they thought of the review. 88% of people who responded to our sort of data gathering told us that they were worried that this review would lead to less protection of rights. And 100% of people said that the Human Rights Act in its current form was important to them. Now, the Independent Human Rights Act Review's report is over 500 pages, but this is the most important bit for us. And this is in paragraph 46 of the report, which sets out that the vast majority of submissions received by the Independent Human Rights Act Review spoke strongly in support of the Human Rights Act. They pointed to its impact in improving public administration for individuals through developing a human rights culture. And the panel were really strong in saying that the Human Rights Act was not, or not just, to be viewed through the prism of a few high-profile cases, or indeed with a focus on litigation at all, and saying actually what the Human Rights Act does is much more than just allow legal cases to be taken. The fact that the law exists and all of the framework within the law means that every single day public bodies have a legal duty to respect, protect and fulfil human rights in everything they do. And what that does is it contributes to a culture of respect for human rights across the UK. Of course, that's not always the case. Sometimes rights aren't respected and protected, and then there is legal remedy available so people can take a case to court here in the UK or in Strasbourg. So what are the proposals? What's happening? What are the government saying they're going to change? Now, when I go through these slides, I've put in some videos just so it's not just my voice that you're hearing, but they start really immediately so that someone else will just start speaking, but you'll get used to it. So the first of our key concerns is democracy, basically, and there's no democratic legitimacy in what's happening. So the Bill of Rights, the consultation, completely ignores what the Independent Human Rights Act Review said. And that was a review commissioned by the government themselves, which leads us to think that what's happening now was a foregone conclusion. So there was always a plan to replace the Human Rights Act with the Bill of Rights, regardless of what people told the Independent Human Rights Act Review, and probably regardless of what we now tell this consultation, which closes on the 8th of March. And that's actually set out within the consultation itself. The government say that in due course, they'll put forward legislative proposals to Parliament to revise and replace the Human Rights Act with the Bill of Rights. Our other concern is the lack of evidence for these changes. So the evidence that we've heard from the government about why they want to replace the Human Rights Act seems to rely on a really small number of cases, some of which aren't even the case in the law anymore. One that Dominic Raab loves to use is around immigration. And actually the law changed in 2014, which means that what he's saying is a problem isn't actually a problem anymore. Our other concerns lie in the inaccessibility of the process. So it's 124 pages, perhaps, the consultation document. It's really technical, and it's a document which impacts all of us and all of our rights every day and how we access those rights. Yet, actually, people being able to respond to it, it's really, really difficult. It was until today only available in English and Welsh. We've seen today, after much, much pressure from civil society, an easy read version being published. Now, it's not an easy read version, it's at best a plain language version. But the most shocking thing is that it's been published today on the 24th of February, and they haven't moved the deadline. So if you're someone who requires, who has different kind of communication needs or access needs, you've only got 12 days to respond. Whereas if you don't, you've had since the 14th of December. So that goes against the government's own consultation principles, which say that there should be a proportionate amount of time to respond, and is discriminatory. So we're challenging that. We can't believe that that's what's happened. We thought that when the easy read version was finally published, there would be a further 12 weeks given, but that's not what's happened.
Got no sound coming through on that.
Oh, sorry.
It's all right.
I'll be able to get you sound. I'll just need to stop sharing and start sharing again. Give me 2 seconds. That came about fairly abruptly anyway, so maybe we should start it again. Let me try.
Consequences. This is a capture. This is an attempt to give to move power and change the balance between the executive and the people. It's a power grab by those who are currently in power, and it really will have serious consequences.
So that is Baroness Kennedy speaking at one of our events. She's a QC, and what she's referring to there is about this power grab. So it's a power grab from the government. The Human Rights Act, as I said at the start, exists to set limits on the power of the state. So if you have a state who are then editing or amending the Human Rights Act through no democratic process, then we are seeing a decrease in the accountability of the state through these proposals. And it comes within a context of multiple different bills which are passing through Parliament, which do the same thing. They take away the legal duties on the state to uphold rights. And I've put a few of them on the slide there as well. And you're about to see another clip from Martha at Liberty, kind of reflecting on this context.
So in court, in Parliament, at the ballot box, in the streets, this is a government intent on shutting down avenues of accountability. And the Human Rights Act consultation is a key plank of that agenda. And it fundamentally changes the relationship between citizen and state, and means that access to justice, access to remedies for human rights violations, and of course, a culture of rights protection in state authorities will be seriously eroded.
Next in the list of concerns I'm trying to get through as quickly as I can is that the proposals in question 8 set out the addition of a new permission stage. So they say that now with this new Bill of Rights, people should have to demonstrate that they've been subject to significant disadvantage in order for their case to be heard in court. Now, under the current Human Rights Act, that's already the case. You have to prove that you are a victim of a human rights breach in order to take a case. So our perspective on this is that what that's doing is it's making it harder for people to even get in the door in the first place to take a case against the state. Second bit that's concerning around access to justice or remedy is the focus within the new Bill of Rights on responsibilities of individuals. And what the new Bill of Rights says is that when a judge is deciding on the damages to be awarded to a person, they'll be able to take into account the person's past conduct. So not just the claimant's conduct within that case that they're talking about or looking at, but past conduct entirely across the whole of a person's life will come into the decision of the court to award remedy to an individual. So it's a really dangerous path. Human rights law exists to make sure that everybody is equal. We're all human, we all have the same rights. What this suggests doing is saying that your legal remedy will be dependent on whether or not you're a good or a bad person, essentially. So the core principle of universality is at risk. Another key concern, the new Bill of Rights within question 11 asks how the government can make changes to the existing positive obligation under human rights law to respect and protect rights. And there's no evidence, you know, it doesn't say this is why we should do this. It simply says, do you think that we should limit the state's positive obligation to protect rights? The positive obligation to protect rights is so important. It sets a proactive duty on the state to safeguard people where they know or should know that someone's rights are at risk. And it was the positive obligation which meant that 2 of the victims of John Morboys, the black cab rapist, were able to take the Metropolitan Police to court and win for their failures to protect them from being treated in a way which amounted to inhuman or degrading treatment. The positive obligation is what means that if someone dies in police custody or in a care setting or in prison, that's the duty that says that there has to be a jury-led inquest into what's went wrong. And it's also the reason that the Hillsborough families in 2014 got a fresh inquest, which led to more justice than had happened already. And there's a quote there from a family member of someone lost at Hillsborough who says, "I don't think we would have got the verdicts in April of this year if it hadn't been for the Human Rights Act." Couple more key concerns to try and cover. Questions 12 to 14 of the Bill of Rights consultation propose changes to or removal, full removal of Section 3 of the Human Rights Act. And Section 3 of the Human Rights Act is the part that says that judges and public bodies should read and apply other bits of legislation in a way that's compatible with human rights law. So if they remove that duty or change it, it will dilute the court's power to interpret other legislation compatibly, and crucially, it will dilute the legal duty on public bodies to apply other bits of legislation in a way that's compatible with human rights. So we see that every day, where we work with public bodies who are using the Mental Health Act, for example, or the Mental Capacity Act, and they have to make sure that when they're limiting someone's right to liberty, for example, under the Mental Health Act, they're doing that in a way that's compatible with human rights law. So it's such an important part of how the Human Rights Act works. And this is actually from a blog written for us by a parent of a child who was held in mental health services. So I'll just read it out as quickly as I can. And she says that the Mental Health Act gave legal powers to put my child in a seclusion cell for weeks at a time. It gave powers to put my child in metal handcuffs, leg belts, and other forms of mechanical restraints. It gave powers to transport him in a cage from one hospital to another. My child was not a criminal. He was in distress, frightened, and alone. The Mental Health Act gave powers to deny contact between us, to take away his mobile phone, access to a computer, his contact with the outside world. And I'll just I'll skip to the end bit, but you can have a copy of these slides. And what Kirsten says is, without the Human Rights Act, the Mental Health Act is often applied in a way that breaches rights. And the Human Rights Act is what gives power to individuals and their families to say, this law needs to be applied compatibly with human rights, and to challenge practice. And it also gives practitioners working within public bodies that ability to relook at what they're doing and say, okay, we have the powers to seclude this individual, but in order to uphold rights, we have to look at doing this differently. So it's such a key bit of legislation and practice for people. The Bill of Rights also suggests changes to Article 8 of the Human Rights Act, which is here. I'm just going to show you what's covered under Article 8. Huge right. It covers our private life, our well-being, our autonomy, our relationships. It covers our ordinary family life. It covers enjoyment of our current home. It covers our communication with others. So it's a huge, huge right that impacts us every day. Yet in the Bill of Rights consultation, it's focused on almost entirely through the lens of deportation. So the consultation document is preoccupied with deporting foreign criminals, and deportation appears in 13% of the document. And what they're saying is we need to narrow the scope of this right so that we can deport more foreign criminals. They're saying that Article 8 stops them from doing that. You could argue whether that's true or not all day long, but that's the argument that's being made anyway. And important things to say about that are firstly that the state shouldn't be the ones deciding who can access rights and who can't. The purpose of the Act is to put limits on the power of the state. But also importantly, even regardless of whether you think the Human Rights Act should be used to do that, that's not the way it works. So if you limit the right to private and family life, you're not just limiting the right to private and family life for dangerous foreign criminals. You're limiting the right to private and family life for everyone, because we all have the same rights. So if you change it for us all. So that's something that's not being explained and something that's really, really worrying. And that's just a reminder. And then final concern is about devolution. So there's 29 questions on this consultation document. Only one focuses on how the Human Rights Act reform will impact Scotland, Wales and Northern Ireland. It's hugely concerning for lots of reasons, not least because in Scotland and Northern Ireland, and partly in Wales as well, there are moves to build on human rights. So Scotland are looking at a Bill of Rights for Scotland, which takes the existing rights in the Human Rights Act and adds to them. Now, if you alter the Human Rights Act, then you are hindering the process of building on that act with further broader rights. And the concerns in Northern Ireland are hugely concerning because the Human Rights Act alters the Northern Ireland Act, and there's then a risk of that destabilising the constitutional settlement in Northern Ireland, and alongside that, the peace process. And you're about to hear Brian Gormally of the Centre of Administrative Justice in Northern Ireland explaining that much better.
That the incorporation of the European Convention on Human Rights into domestic law and the Human Rights Act in particular are especially important to Northern Ireland. We had a 30-year violent political conflict during which the state committed numerous and deep human rights violations, in addition to atrocities by illegal armed groups. Part of the deal to end the violence was that the state be reformed and human rights were to be protected in a whole variety of ways.
Okay, Natasha, I've got about 2 or 3 more slides. Do you want me to finish them, or I can come back and do a summary at the end if there's time?
You may as well carry on.
Okay, I just don't want to eat into anyone else's time. So the final bits to say are, what does this mean for journalists? And we focused a lot more on that in workshop 1 because we talked a lot about kind of how to report and these things, but just a quick sort of run through. Journalists have such a key role to play in public understanding about human rights law, especially in the context of Human Rights Act reform. Lots of the evidence being used by government ministers to justify reform is out of date, and it depends on the public not understanding how the Act works. And we need journalists to be able to present the facts. Freedom of the media is essential to the protection of all other human rights, and instances of torture, discrimination, corruption, misuse of power often come to light because of the work of journalists. So it's crucial for preventing and redressing human rights issues that journalists kind of understand this law and can speak about it in a way that makes a difference. The Human Rights Act exists to hold the state to account. Human Rights Act reforms are sometimes disguised as protecting the public. They say we're doing this because the public are sick of dangerous foreign criminals, when actually what's really happening is that everybody's rights are being limited, but that's not always understood because people don't understand that that's how the Human Rights Act works. So if you limit rights for one group, you limit rights for all of us. So we rely on journalists to put that message across accurately. And of course, the Human Rights Act protects journalists from the state too. And I think Charlie he'll talk a lot more about freedom of expression and those things soon. So top tips for using human rights: upskill yourself on the rights in the Human Rights Act, make the connections to human rights. That goes a long way to a culture of respect for human rights in the UK. Use the Human Rights Act to hold the state to account when you are reporting. Tell the everyday stories of the Human Rights Act. the good ones, the ones where people are using the Human Rights Act in hospitals and care homes and schools every day to respect and protect rights. Use the language of human rights law, not the language of human rights principles or values. And we talked about this last time, but it's so important to report the outcome of a legal case. We see lots that says, this person used the Human Rights Act to get KFC sent to them, but we don't ever then see the bit that says, and it failed, because that's not what the Human Rights Act does. So we really kind of, urge journalists to do that. Please respond to the consultation. We've got Annie, my colleague, might be able to post in the chat. We've got everything you need to do that, and Liberty have got lots of resources as well. We've got a question by question guide. We've got a letter template response. We've got surveys. If you don't want to respond to the consultation, go onto our survey. There's 15 questions. Tell us what you think, and we'll put your answers into our response. And then finally, can I ask if you've got a mobile phone beside you, or you're obviously on a laptop, so you can just exit full screen, that you quickly go on to slido.com. You can scan the QR code if you're feeling fancy, or you can type in the code, which is 625457. And there's a question there I'd love for you to answer. And it's anonymous, so you can be completely honest. And it says, are you concerned about Human Rights Act reform? You're going to get a chance in just a second to say why or why not. Okay, I'm just going to leave that poll open for another 10 seconds, and then I'm going to move it on. Thank you. And this is the final question. So if you are concerned or not concerned, you can say why, and just try and do it in 4 or 5 words, or 1 word, or whatever. Keep it short. That's one way to say it in 1 word, yes. I'm just going to leave this up for another 20 seconds. So. Okay, finish up answering now if you're typing something. Thanks very much. And yeah, there's not much else to say on that. Thank you so much for listening and giving me a little bit extra time, Natasha. And also I'll be here for questions after as well.
Thank you ever so much, Carlin. Yeah, that gives us a lot of food for thought. And I think the thing that concerns me so much is how inaccessible the whole consultation is. And especially for those who most need their human rights. I think that doesn't speak to the actions of a state that wants to protect people. So yeah, thank you very much for that introduction. We will hand over now to Charlie Welton from Liberty. So thank you very much for joining us, and I will spotlight you now.
Thank you so much. It's really, really great to be here. I'm going to try to share my screen as well. So I hope that is working and people can see a big green slide. I will warn everyone that my slides are nowhere near as exciting as Carlin's. No videos, no participation, anything like that. But you know, sorry, you're stuck with me now. So I'm here to talk about the government's proposals as they relate to freedom of expression. And I felt that the best place to start on this is before we actually get to the proposals themselves. We talk about the framing and the selling of this whole process. Now, if you've heard Dominic Raab or anyone from the government talk about this initiative, this replacement of the Human Rights Act with a Bill of Rights, you've probably heard this justified on the basis of at least one of these justifications, whether that is that it will help facilitate deportations, that it will help us take back control from European judges or assert parliamentary sovereignty, if it's just all about punishing criminals, or indeed freedom of expression. And freedom of expression is important for the selling of this, because along with this proposal to enshrine the right to trial by jury, it's really the only positive facing proposal that there is in there. When I say positive, I don't mean a sort of value judgment or anything, anything like that. I mean that it's about strengthening or expanding rights. And without these, and I would say that the government has become quite a bit quieter on jury trials since the Colston 4, and there've been a lot of suggestions from Conservative MPs and indeed the Attorney General that they might do something about that inconvenient judgment from the jury. You're left with what could be really quite a historical anomaly, in that this is a new Bill of Rights that actually only weakens rights protections for people. So the idea that there is something that's going to be strengthened is important. And just as a measure of how important this is to the government, I was very surprised to see on the day that the consultation was launched that the Daily Telegraph, which has had so many problems with the Human Rights Act, didn't actually mention the Human Rights Act at all in its headline announcing the consultation. Instead, it went with new free speech law to protect against wokery and cancel culture. Now, I mean, we'll get on to talking about the proposals, and there is certainly some stuff that does relate to freedom of expression. This is why I'm here. But the idea of calling it a new free speech law is really quite bizarre when you consider the scope of what is being proposed. And I think wokery and cancel culture is well, I mean, it's just things that they like to talk about, really, isn't it? But so if this is the framing, let's go on to the proposals themselves. Now, there are 4 questions that directly address freedom of expression in the consultation. But I do want to kind of emphasize when I say that I emphasize the word directly, because these are absolutely not the only questions in there that relate to freedom of expression, and I will kind of come back to that in a bit. But there are these 4 that deal with it specifically, and they ask about Section 12 of the Human Rights Act, and especially how it can be amended to limit interference with the press. They ask about Article 10 and how the scope for interference may be confined to limited and exceptional circumstances. They ask about stronger protection for journalist sources, and then a general sort of catch-all question at the end: what else can we do, sort of thing. A cynic might say that that's separated out just so there's more questions that seem to ask about strengthening things out of the 29. But anyway, these are the ones that are here. So to go through them in turn, question 4 deals with Section 12 of the Human Rights Act, asking whether it should be strengthened. And what I have there on screen is 12.3 and 12.4, which are the bits that the consultation document asks specifically about potentially amending in some way. So 12.3 is about interim injunctions, and it asks whether it should make it a higher test, so higher than it being likely to establish that that publication should not be allowed. Should it be higher than that? Should it be something about it being exceptional? And 12.4, which it suggests has had, so 12.4, the court must have particular regard to the importance of freedom of expression. And again, it asks whether this should be raised should be strengthened in some way so that it's exceptional if there should be any infringement upon it. Now, what I would say first of all is that Section 12 of the Human Rights Act was very much inserted as a result of a lot of lobbying from the press, and it does represent a higher test and a more significant bar than what existed before. Previously the guidelines were around there being a serious question to be tried and a prospect of success at the trial, and this was very much a raising of that. I would say as well that with Section 12.4, the government asserts that there's been no real effect of this proposal, and really we would have to disagree quite considerably with that. I know certainly there have been some, one in particular rather prominent case recently, which I'm sure we'll talk about in the Q&A. But overall, I think that this is a problem with data more than anything else. This idea that it has not had effect. When you get a situation in which a court must decide whether an injunction is to be allowed, that has usually come because there is something at risk here, that the publication knows that this might be a story that they could be at risk of being sued over. If they believe that they have the strong case, they're more likely not to give prior announcement of it, and so there's less likely to be that data of cases that are won on Article 10 grounds. I'm going to come back to this, but I'm going to move on first to the next question, which is Article 5, and it's talking about potentially confining the scope for interference of Article 10 to limited and exceptional circumstances. Now, the thing about this is that it's one of many questions in the consultation that reads in a vacuum like something rather positive, and then you read into how it interacts with other things, and you read the justifications for it, and you begin to see what is actually being asked. So this is much less a question about enhancing Article 10 and more a question about undermining other rights, and in particular the right to privacy. It is talking about rebalancing the tests that courts will do, so that Article 10 is elevated above Article 8 in particular. However, it's not only asking that, because I mean, imagine that this is a room in which we are journalists in the room who I imagine would be quite happy with, in certain circumstances, freedom of expression being raised above privacy. However, there are other things that we must think about in this. So, in talking about limited and exceptional circumstances for infringement or interference of Article 10, this is a very tricky thing to get into. Once the government begins to actively define in a Bill of Rights what the circumstances for interference with Article 10 can be, this will reach an area in which you're essentially putting down areas in which Article 10 protections may not apply. It will remove the court's ability to undertake careful evaluation of certain circumstances, including balance of rights analyses on specific sets of facts, and you could end up with a weaker Article 10 as a consequence. There's another way in which this, which proclaims to be upholding Article 10, could have the opposite effect. Now, Article 10 is a qualified right. Elsewhere in the consultation, at question 23, the government asks about qualified rights and how best to balance them. Now, this is not balancing with other qualified rights. This is balancing with the public interest and with what Parliament, the will of Parliament. Now, you don't actually even have to go all the way to question 23 to see where this is a problem with question 5, because actually it's in the consultation document in the bit that is introducing the questions on freedom of expression. While it's saying that we want to uphold Article 10, we want to uphold freedom of expression, It says at paragraph 216 in the document that we know that freedom of expression cannot be an absolute right, balanced against national security, protecting against harm. But also, where the government believes that where Parliament has expressed its clear will on issues relating to the public interest and the exercise of public functions, this should be given great weight. Now you put this together with question 23, and really you see that what they're saying here is not so much that we really care about Article 10 and we want to elevate it above other rights. It's that we want to reduce all of these qualified rights below whatever it is that we're saying and however it is that we are legislating. We want to restrict your ability to challenge these pieces of legislation. However, we want to restrict certain of the other rights, such as privacy, to a greater degree than we do Article 10. So while it may be a relative increase in the sense that it's a tipped seesaw, it's an overall restriction. Moving on quickly to question 6. Question 6 asks what further steps could be taken to provide stronger protection for journalist sources. And I've provided here the only paragraph in the consultation document that talks about sources. As you can see, it's 2 sentences. It has no detail. It has no suggested provisions, no draft clauses. It doesn't even give examples of what the problem currently is. Why is this a problem with the Human Rights Act that needs to be replaced with a Bill of Rights? Now, journalist sources, as I imagine some people in the room will know, these are protected under the Contempt of Court Act, along with Article 10. And this is somewhere in which we have really benefited from Strasbourg jurisprudence. A lot of the protections for journalistic sources in our law currently come from cases that were taken to the European Court of Human Rights. And such as the famous case of Goodwin and the famous case of Financial Times. And what is actually particularly interesting about this is that these are cases which, in fact, in both of those examples, these were cases against the United Kingdom. So not only is there something of a question as to what exactly is the problem that you're talking about, and I don't mean to say that there is no problem with protecting journalist sources, because I'm sure there is, but what is the Human Rights Act not doing that you think the Bill of Rights could do? But also, again, when you look elsewhere in the document, we have many, a number of questions that look to reassess our connection to not only Strasbourg, but also really the European Convention overall. For example, we have question 1, which again, it's one of these things where you have to really dig into what the actual question is, but it's talking about drawing on a wide range of law. And as you can see, as the extract from a draft clause shows, it says that it's not necessary to construe a right or freedom in this Bill of Rights as having the same meaning as a corresponding right in the European Convention on Human Rights. So there's a decoupling of what the rights in this new Bill of Rights would mean here versus in the European Convention. Also, you have question 28, which asks about responding to adverse Strasbourg judgments. And again, an extract from the draft clause states that the judgments and decisions of the European Court of Human Rights are not part of the law of any part of the United Kingdom and cannot affect the right of Parliament to legislate. Now, again, what we're doing here is that we are trying, the government is trying to decouple as much as possible from the case law of Strasbourg, and really from what is understood by these rights. And I think that the example of journalist sources is a really important one in looking at this, just because of how much of the protections that we have right now come directly from that case law. And it makes you wonder where we may end up a few years down the line if all of these proposals come into force. I'm not going to spend much time on this last one, because I mean, they've not spent very much time in thinking about it either. I think it's a very clear thing. What other steps can the government take to strengthen the protection? Well, I would say, why don't they look at the other pieces of legislation that in fact they're involved with at the moment? The Police Crime Sentencing and Courts Bill, this consultation on reforming the Official Secrets Act, the Online Safety Bill. Indeed, why are you getting rid of the Human Rights Act? In fact, I would speak a little bit more about the Official Secrets Act. And really, if you want to improve protection for journalist sources, indeed protection for journalists, I think it is baffling that you're asking about removing the Human Rights Act while progressing with reforming the Official Secrets Act. You know, the proposals on the table in what I think will become the Counter-State Threats Bill include treating journalists like spies, and giving them up to 14 years in prison for inconvenient reporting. They've rejected the suggestion from the Law Commission to institute a public interest defence, which seems to me to be a much better route to protect journalist sources than anything in the Bill of Rights. I mean, while we're talking about it, if you do want to protect journalist sources, why not go to the enabling legislation rather than a Bill of Rights? If there are too many orders under the Police and Criminal Evidence Act, or the Terrorism Act, or the Investigatory Powers Act, then why not reform those, as opposed to dumping the Human Rights Act and bringing in this really quite ridiculous Bill of Rights. I've shot through this quickly, and I'm sure we're going to have a good discussion, but I hope this gives a useful overview to start off with what I think are really the implications of what the government is looking to do with freedom of expression. Thank you.
Thank you very much, Charlie. And again, it demonstrates how complex it is. And, like you were saying, there are some questions that initially look quite positive on the surface, but that's really quite misleading. And to have to refer to different bits of legislation, different parts of the consultation to work out what it is that you're trying to say is really, really concerning. And again, the Official Secrets Act reforms a huge concern for journalists as well. And I know that Chris will more eloquently kind of cover some of these issues than I will. So thank you very much, Charlie, and I will hand over to Chris now.
Thanks very much, Natasha. And thanks as well, particularly to Charlie and Carlin, who I think have covered the ground extremely well, explaining why the bill is Bill of Rights is wrong, and why we should stick with the Human Rights Act. I mean, I found it quite instructive looking at the review document that Rob introduced just before Christmas, because it underpins the way that this government works. I mean, they talk about phrases such as common sense, a healthy dose of common sense, they say. And it's clear this sort of war on woke, which was identified, I think, by Charlie in the Telegraph headline, is part of this sort of dog whistle approach, a call to those who struggle to deal with life and see the government wanted to do something, but they're not quite sure what. And it gives the government the opportunity to present apparently easy solutions to problems, which are then supported by a number of our colleagues in the right-wing press to come out with these kind of ideas: cancel culture, war on woke, and we see it over and over and over again. And they're using it to justify getting rid of the Human Rights Act and replace it with a Bill of Rights without any real understanding, I don't think, about what the actual problem will eventually be, but clearly attempting to try and reduce our rights, reduce our ability to challenge the government and to move on. I mean, Rob's plan talks about a proper balance. what does that mean? A proper balance between what? He doesn't mention that. And that it allows for more scope in interpreting European Court of Human Rights rulings to end gold plating of decisions. And again, this is just nonsense. I don't understand what that can possibly mean. So they're trying to attack rights. They talk about strengthening quintessentially British traditions such as freedom of speech and the right to jury trial, but go on to ensure a system that clearly is not doing that. And I won't batter that to death, because I think Charlie and Carlin have done a much better job of that than I could, explaining in real detail exactly where those things are going wrong. But they are all important to us because freedom of expression underpins what we do as journalists. And it's not just the sort of freedom of expression in that broader sense of the term, but what the Human Rights Act says is that people have the right to receive and impart, excuse me, and impart information without interference by public authorities. And that's what we do. That's our job. That's what journalists do. We gather information, we receive it from a whole range of sources, and we impart that to the public. And it's important that we should be able to do that without interference from public authorities. And it's a right that's reinforced in the Human Rights Act. It's difficult for me to see how they could possibly strengthen that with a Bill of Rights. Therefore, quite clearly, this is an attempt to fool us, and it's going to be reduced at some point. We have to ask ourselves, why would it change? Why is it presently open to abuse, our right to freedom of expression? And who is actually doing the abusing? I mean, is it journalists? Is it publishers? Is it broadcasters? Well, I don't think so. What I often see, though, is abuse coming from the government as they attempt to close down debate, that it comes from their rich supporters constantly using slaps, strategic lawsuits against public participation. And those are the kind of things that are trying to close down the right to freedom of expression, not anything that ordinary people are doing. And whilst the Human Rights Act carries a number of caveats about things like the protection of health, protection of morals, the reputation of others, the right to national security and public safety and so on, that's all dealt with in additional legislation, which would still already be there in any case, and that doesn't change. So we need to consider, and Charlie's certainly mentioned it, some of the other things that are there, the ability for us to receive information so that we can then report it on. And that comes through a number of sources. The various cases have been mentioned. Bill Goodwin is one of the famous cases from our perspective. We fought that through to the European Court, where the European Court of Human Rights said that his rights to retain his sources confidentially had been impinged by the courts in the UK. But this government, well, to be fair, no government since then has changed that to ensure that we have a stronger right to protect our sources in this country. But I don't see that this Bill of Rights is going to make that better, because the government quite clearly doesn't want to make that better. And looking at the Official Secrets Bill and the Police Crime and Sentencing Courts Bill, which is due to have its final consideration of amendments next week, I think, all of those are introducing things that reduce our rights as journalists to access information, to get the information, and then pass it on to other people. So from that perspective, professionally, the Human Rights Act is incredibly important, and I've always thought that we do not do enough as journalists to support the kind of work it's doing, the way it's underpinning our rights and the rights of others. There's another set of rights, though, that we need to give particular consideration to, and those are our rights as trade unionists. And the NUJ is a trade union. We're there to protect our members in the workplace, just as any other trade union. And the Human Rights Act gives us the right to do that. It gives every person the right to belong to a trade union. It gives every person the right not to have that labour taken for granted. If we want to go on strike, we have the right to do that under the Human Rights Act, because slavery is banished. and therefore we can choose whether we work or whether we don't work. And that's an important right. There's also the right to peaceful assembly, allowing us to come together. I mean, in meetings such as this, debating issues like this is a major human right, to be able to come together, discuss issues, to try and pursue a particular course of action, but also to assemble outside. And we know there's been a lot of concern about the rights to protest in the new bill, and whether we would be still allowed to do that. So all of the government's movements have been to whittle away our freedoms, whittle away our right to do things, and that all comes from trying to whittle away what the Human Rights Act is all about. So changes to the Human Rights Act that they claim are improving it are not just tinkering with a good idea. It's clearly an all-out attack on our rights as journalists, our rights as trade unionists, but also, frankly, just our general rights as citizens, our rights to be protected on a whole range of things, which Charlie and Carlin have mentioned very importantly. And we need to ensure that we are informing the public of the importance of their rights, frankly, before they're taken away. And we may not have that much time in which to do that. So we need to take that seriously. So I'll end there, if I may, Natasha, and let people ask questions. I just wanted to stress those very important things as they affect us as NUJ members.
Thank you.